Good morning, Jonah. I hope to keep this matter brief and respect the fact that the court has a busy docket. This morning we just basically have to address a simple math problem that has found the prosecutor examined the petitioner's inartfully pleaded complaint inscrutable, even as a graduate of Virginia Commonwealth University, finding no justiciable claim to merit saving the faintly articulated issues and enigmatic allegations in the petitioner's complaint and warrant, and even the solicitude with which our courts seek to protect the rights of unrepresented litigants. As the state Supreme Court has warned in lower courts on multiple occasions, they should not seek to quash complaints brought by plaintiffs, depriving them of their right to their constitutional guarantee of day in court. But while Congressman Don Byer had made headlines in Newsmax for the generally accepted proposition that even the president is not above the law, our courts have always repeated that sovereign immunity is alive and well in Virginia. And at least under Uribe v. Sessions, one way in which that claim may be overcome is when the conduct simply shocks the conscience, which petitioner believes credibly to be the case before this honorable court this morning. As stated in the matter in Ray Winship, due process clause protects the accused against conviction except upon proof beyond a reasonable doubt of every fact necessary to constitute a crime with which he is charged. And it is the rule even in the Commonwealth that one who aids and abets another is accessory after or before the fact. Pertinent materials are that, as asserted in pleadings, the former governor on repeated occasions has described the novel coronavirus as a highly contagious disease, and at least once at a press conference on April 27, 2020, in the record, as well as immediately after his infection in September 2020, while, without a reasonable doubt, the largest sample size trace contact study published on November 6, 2020, had revalidated the clinical finding that COVID-19 possessed a secondary attack rate of less than 5%, at least 12 times too low to be clinically described as a highly contagious disease like 60% secondary attack rate smallpox, which Martin Blazer had established by at least 1982 would have been only then capable of setting off a super spreader event. The Third Circuit had recently addressed the issue of prosecutorial discretion, as respondent had raised in a similar matter brought by petition. In U.S. v. Houck, not directly addressing the controlling statute in the Commonwealth, that court had observed, quoting Bordenkircher v. Hayes, that the decision whether or not to prosecute and what charge to file or bring before a grand jury generally rests entirely in his discretion. And that court quite specifically had concluded that conscious exercise of some selectivity in enforcement is not in itself a federal constitutional violation so long as the selection was not deliberately based upon unjustifiable standards such as race, religion, or other arbitrary classification, quoting Weller v. Boyles. Petitioner, as a member of a suspect class alone, would be entitled to strict scrutiny, especially in a case involving an issue of public health that had found by August 2020 as many as 60% of the fatalities in Richmond being not just persons of color, but of persons of African descent, and for whom even the last governor had made the noble affirmative action to designate a new state holiday preceding even the current president, to celebrate the emancipation of the slaves in the Texas territories of the vicinity of Galveston 2 months after the surrender of General Lee at Appomattox Courthouse. As the courts have said, with regard to substantive rights at issue here, due process is the right to be heard at a meaningful time, in a meaningful manner, and of record, respondent had filed his motion to dismiss back in January, and now 6 months later has yet, for unknown reasons, even sought to have that matter docketed for hearing, prompting petitioner's most respectful request to proceed to a pretrial conference with no further delay on a matter at least tangentially related to the deaths of 232 residents of Alexandria and almost 45,665 infections, like the three at issue in this case. Begging the indulgence of the court for just a few minutes further, petitioner, who had attended college in the Commonwealth and Shenandoah, had found references to some of the finest state colleges in what is recognized to be the seventh most educated state in the nation, falling just behind New Jersey, and most would agree that the University of Virginia, a state partner in the former governor's COVID-19 response, is recognized as the premier state college in the Commonwealth, if not the College of William and Mary, both of which had been among petitioners' choices as residents from out of state almost 4 decades ago. With a slightly higher acceptance rate than the HBCU Howard University, which accepts only 35% of its applicants, William & Mary accepts 37%, while UVA, with its much revered honor system and heritage traced back to former President Thomas Jefferson, a man of great scientific achievements, accepts only 21% of applicants. Like some far less competitive colleges across this great state, described as often the cradle of the presidents and this great nation. And any child who is granted the distinct privilege of acceptance at these premier institutions should most certainly, and quite deservedly, I might add, have made some families and friends quite proud, as well they should be. However, according to the science experts who had declared the pandemic by late February 2020, looking at 19 times more cases than had yet been reported in the entire United States in March 2020, when the former governor had taken swift and decisive action so as to avert an inestimable loss of life, I believe the former Attorney General had argued persuasively to the court's satisfaction. During an unprecedented pandemic, they had believed that you had a chance 4 times higher of getting accepted to UVA, a fine college, or 7 times higher to attend the College of William and Mary, than being infected by this novel coronavirus, which, according to the Virginia Department of Health, had found today the number of cases in the entire Commonwealth totaling 2,310,846, about a quarter of the population of the state, and yet an increase of about 3.6% since respondent had filed his motion to dismiss in January, while there are now 23,441 fatalities statewide, or about a 2.27% increase since this matter of dismissal could have been decided a half year ago. And for no reason articulated for this delay, while arguably acceptable losses of life have now occurred, compared to the mere 45 cases and 1 fatality that had served as the rationale for locking down the entire state, resulting in immediately an increase in unemployment claims by tenfold, according to the business leader, the equivalent of the Hurricane Katrina in every state, according contemporaneously to reporters at Axios. One case upon which the former Attorney General had relied was the matter of U.S. v. Chalk, decided during the turbulence and social unrest of the 1960s, and the Fourth Circuit had noted that dealing with an emergency situation requires an immediacy of action that is not possible for judges. And prudentially, for that reason, in evaluating measures taken during an emergency, the scope of the court's review must be limited to a determination of whether the executive's actions were taken in good faith, whether there is some factual basis for the governor's decision that the restrictions he imposed were necessary to maintain order. But much like law enforcement have a use of force doctrine where adrenaline is rushing and tempers are flaring, the military in which petitioner had served has found it most useful at some point to conduct, if not an in-progress review or IPR for actions on the objective when practicable, then certainly to conduct an after-action review or AAR. And in Chalk, the court had expressly articulated a rule emphasizing again prudently that not even the grant of license to the police powers was plenary. Quoting another restricting precedent, all power may be abused if placed in unworthy hands, from Luther B. Borden, and indicating that the courts cannot prevent abuse of power, but can sometimes correct it, and such time with determination of the state of emergency surely has come. And most concerningly to petitioner is that what amounts to a Harvard acceptance rate coronavirus, according recently to the CDC, has incredibly found beyond any rationality. As many as 77.5% of Americans have accomplished this remarkable achievement of having been infected, short of death, like the Davidsons and the Gravesons, who had been members of the First Baptist Church of Alexandria, and about whom, at least regarding the infections of the Gravesons, even the Washington Post had posed a reasonable question recently asked by the New York Times after the 149th running of the Kentucky Derby had circled down. What are the odds? While the prosecutor, asserting a prosecutorial discretion, finds no shock to his conscience, You simply turn his head in the other direction and look away. Nothing further. John. This message was approved by Major Mike Webb. Honest.